Chief Justice of the Eastern Caribbean Supreme Court, the Honorable Dame Madam Justice Janice Pereira, other Chief Justices of Belize and Jamaica, Attorney General and Minister of Legal Affairs of Barbados, the Honorable Dale Marshall, other Attorneys General and Ministers of Antigua and Barbuda, Belize, St. Kitts and Nevis, and St. Lucia. President of the Caribbean Court of Justice, the Honorable Mr. Justice Adrian Saunders. Former Chief Justice of Belize, Mr. Kenneth Benjamin. European Union Ambassador to Barbados, Your Excellency Malgorzata Vasilewski. UN Resident Coordinator for Barbados and Eastern Caribbean, Mr. Didier Trebuch. Justices of the Supreme Court, judges of the Court of Appeal and High Court judges, directors of public prosecutions of Barbados, Guyana, St. Lucia, and St. Vincent and the Grenadines, permanent secretaries, resident representative of the United Nations Development Programme, Multi-Country Office for Barbados and the Eastern Caribbean, Limia El Tabia, other resident representatives of the United Nations Development Programme, other partners, distinguished guests and delegates, live stream audience, members of the media, ladies and gentlemen, good afternoon. Welcome to the launch of the PACE Justice Project, a partnership of the Caribbean and the European Union on justice. This partnership on justice is a criminal justice reform project implemented by the UNDP of Barbados and the Eastern Caribbean with funding from the Delegation of the European Union. It will reduce case backlogs in the criminal justice system by enhancing the institutional capacities of prosecutors, courts, prisons, and police across the Caribbean. It is supported by a number of governments and key justice decision makers, as well as regional justice bodies. To tell us more about the partnership, we have a lady who is very familiar with the Caribbean, having served as ambassador to a number of Caribbean countries before being posted to Barbados in 2020. Prior to her posting as ambassador, she was head of division for conflict prevention, peace, and mediation at the Security Policy Directorate, and before that, she was a senior specialist at Amnesty International. Someone who would be very able to tell us about PACE justice. Ladies and gentlemen, to give us the welcome address, I now invite up the European Union Ambassador to Barbados, Her Excellency Malgorzata Vasilewska. Ladies and gentlemen, the Ambassador.
Thank you. As many of you know, I'm not the ambassador, I'm replacing her. My name is Fanny Steens, I'm the deputy at the EU delegation, and I have to excuse the ambassador. She really wanted to be here, but she had an emergency she had to attend to, so she couldn't come, but she will be there tonight, and I invite you all to come to the residence for a drink, and then she will be there. So, but I will do the speech anyways for the EU. And with your long list of protocols, I would rather say protocols observed because I don't want to miss out anyone in my list. Good afternoon, everyone. It's a real pleasure to be with you today on the occasion of the launch of the Partnership of the Caribbean and the European Union on Justice program, known as PACE Justice. It's a sign of commitment of the European Union and the Caribbean to work hand in hand in the defense of the rule of law and of democracy, as recently reaffirmed by our heads of state and government at the EU CELAC summit in July in Brussels. The objective of reducing the case backlog in the criminal justice systems might sound a bit abstract to outsiders. However, everyone present here would be aware of the crucial importance of this objective for the credibility of our justice systems. This is essential for society as a whole, as it sends out a clear message to potential offenders that can act as a deterrent. Receiving a swift reaction from the justice system is significant for the psychological well-being of victims, as it signals to them that authorities take seriously the injustice they have suffered. Conversely, delays in the process can result in victims feeling re-victimized by having to repeatedly retell their traumatic experiences or endure long periods of uncertainty, what is referred to as secondary victimization. And last but not least, an efficient justice system is important for defendants. I'm constantly saying last but not least, being aware that some might prefer last and least. According to data from the World Prison Brief, 52% of the total Caribbean prison population were being held without a conviction in 2021. Similarly, according to an IDB study, male prisoners on remand spend between 2.5 to 4 years in prison. And there are well-documented cases of prisoners spending more than 10 years on remand. The PACE Justice Program will be implemented over the next 48 months by the United Nations Development Program in 8 beneficiary countries: Antigua and Barbuda, Barbados, Belize, Dominica, Guyana, St. Lucia, St. Kitts and Nevis, and Trinidad and Tobago. I use this opportunity to thank authorities from these nations for your active involvement in the conception of the program, as well as for your presence here today. This is a clear demonstration of your commitment to employing long-lasting solutions to improve access to justice in your respective countries. PACE Justice will ultimately contribute to the goal of a renewed partnership on justice and security for citizens agreed by the European Union and CELAC leaders in July in 2023. The initiative also fully adheres to the new post-Cotonou Partnership Agreement, for which the European Council recently green-lighted the signature and provisional application, and which includes democracy, human rights, peace and security among the priority areas. While political support both in the region and in Europe is essential to the attainment of our goals, we do not underestimate the stakes and the magnitude of the challenges we're about to tackle. It will be a long-term journey, almost a permanent one, as there will always be a need for criminal justice reform. To quote Barbados Attorney General the Honourable Dale Marshall when announcing the establishment of his country's Criminal Justice Reform Committee in May this year. The process will entail significant public investments, which will require clear explanations to voters why government should increase budgets for courts, police investigations, and a penitentiary system, particularly in times of economic constraints and increasing criminal rates. Indeed, nurturing a punitive culture instead of working on a rehabilitative approach may lead to quick political gains, but will not help to find durable measures against the problem. PACE Justice intends to assist in pursuing planned and ongoing judicial reforms, and there are a number of reasons to be optimistic about its impact. First, the program is designed to be demand-driven, with each nation's unique needs thoroughly assessed and solutions tailored based on input from relevant national stakeholders. Second, the choice of UNDP as the program implementing partner. UNDP has a strong record in supporting judicial reforms in the region and implementing programs of this nature. As the PACE Justice Management Team is formatted, it will soon collaborate with your institutions to initiate initiatives. Third, the program is part of a broader effort of the international community in the Caribbean. Other donors, such as the United States, Canada, and the United Kingdom, have been working in partnership with local authorities on rule of law matters and criminal justice reform. We intend to continually build on their achievements and harmonize our activities. I would also like to emphasize 2 other crucial elements of the European Union's cooperation with the region. Our cooperation with the Caribbean Court of Justice is a testament to our close relations and our commitment to working together. This was easily borne out in how strategically the launch of PACE Justice Program was coordinated to coincide with the biannual Criminal Justice Conference organized by CCJ and the Caribbean Academy for Law. More importantly, the CCJ is the final court of appeal on civil and criminal matters for 5 of the 8 beneficiary countries, and the close cooperation with this court would significantly help national jurisdictions to improve performances. I'm also delighted to announce the upcoming launch of the Europe, Latin America and Caribbean Program of Assistance Against Transnational Organized Crime, also known as El Pacto. This program aims to bolster security and justice in Latin America and the Caribbean by supporting the fight against transnational organized crime. El Pacto will involve close interaction and support to crime-fighting agencies in Latin America, the Caribbean and Europe, with the active participation of key agencies such as Europol, Ameripol, Interpol and Eurojust. I take this opportunity to greet the designate Program Director El Pacto, Javier Samper, as well as the designated Senior Program Advisor, Mark Reina, and the Coordinator for the Caribbean, Maite Verhoeven, from the Dutch Ministry of Justice and Security, who are here with us today and will be available for further questions on the program and ways to cooperate. Before concluding, I would like to express my gratitude to Eurojust represented today by Judge José Lamata. His presence exemplifies the kind of cooperation we seek with the Caribbean, a genuine partnership where the European Union and Caribbean justice and law enforcement agencies work together to defend our democracies. Judge Lamata is one of the most experienced judges in Europe in terms of international cooperation, and I'm sure that we will have very fruitful interactions here. Thank you for your kind attention and for your precious work. I wish a successful workshop, and I'm looking forward to the successful implementation of PACE justice. And we're all looking forward to seeing you tonight.
Thank you, Deputy Ambassador. Now, this project will be implemented by the UNDP, and so to give us an insight into the role of the UNDP in this project, we have the resident representative whose experience spans 27 years and 4 continents with work on development and urban planning, local administration, social inclusion, human rights, and partnerships. Before joining the UNDP Barbados in the Eastern Caribbean Multi-Country Office as a resident representative in 2022, she previously served UNDP in Albania, Bahrain, Gambia, Partnerships New York, and Iraq. Ladies and gentlemen, please welcome the resident representative for the UNDP to Barbados and the Eastern Caribbean, Limia El Tayeb.
Good afternoon. I'm really delighted to be here amongst all of you and to see the enthusiasm in the packed room, a real demonstration of partnership. The EU partnership with the Caribbean on justice reform implemented by UNDP. More importantly, I think our presence, all of us here together, demonstrates our collective commitment to finding new people-centered strategies that ensure equitable, timely access to justice. I want to recall and recount a testimony by Wendell Beckles, who states, "I am lost in jail," for he has been lost in jail for 8 years due to a clerical error. This extraordinary story is in fact not so extraordinary. With many of those are in the justice system have seen significant delays due to inefficiencies or the systems that they're working through. Justice denied and justice delayed are the same. Justice delayed is justice denied. We need to address these critical issues through efficient, effective, equitable access to justice systems for the citizens of the Caribbean. To respond to this, crime need not be grounded in punitive ideology, nor in incarcerations, but by exploring methods of diversion and restorative justice. We also have to do it in a way where collaboration and coordination is central to how we are working. The UNDP 2019-2020 Needs Assessment Report on the administration of justice in 9 Caribbean countries confirmed that the challenges are not just about access to justice, but also the quality of justice being delivered. The same report also noted that backlogs and bottlenecks in the system can amount to the retraction of the human rights of citizens. A sentiment I think we all in this room hold dearly and examine quite closely. This was the first report that provided hard data on the challenges facing the criminal justice system after the 2012 UNDP and provided the data for the formulation and conceptualization of the PACE program. We truly understand that there are other partners that have worked in this space and that your findings are similar to ours, and that we collectively need to join hands and harmonize our work to ensure that we are working in synergy and building on each other's successes. Let me take a moment to really thank the governments of the Caribbean, the various attorney generals, the Caribbean Court of Justice, the Eastern Caribbean Supreme Court, the European Union, the UK, the US, Canada, UNDP, and others that are very active in this space in the sub-region. The 2020 UNDP assessment report also states that those on remand account for more than 20% of all prisoners, with that rate exceeding to 50% in some instances. It also points out that backlog is the #1 challenge identified by the stakeholders that were assessed through the report. The reasons for the backlog are multifaceted. The pace of investigation by police, the inordinate delays in production of depositions, the lack of human and technological resources. Some of the recommendations that came out of that assessment included diversionary measures, case flow management, bail, pretrial, and detention reviews, rehabilitative approaches. The PACE program that we are here to launch today aims to reduce current backlogs as well as look at ways of preventing future backlogs. Some of the areas that we will be focusing on include the deployment of hardware and software, interventions on procedural reforms, and alignment of information management systems. This is about ensuring that every individual has fair and equal access to the legal system. It's also about improving the system so that it is not just efficient, but perceived as fair and just by everyone, which is also critical. As I said earlier, the program is a result of all the recommendations of everybody in this room and all our partners, the chief justices, the attorney generals, and many others in the justice chain. But it's also an opportunity where we build on each other's understanding to enrich the nuances of the challenges and opportunities for future collaboration in PACE and beyond PACE. Allow me to take a moment to extend my appreciation to all of those in the room and all of the entities and governments you represent, the attorney generals, the chief justices. A huge vote of gratitude to the European Union for the steadfast commitment to strengthening the justice sector. But also let me acknowledge my colleagues from the SEB region. We have with us the representatives, deputy representatives, and staff members of UNDP from the countries where the program will be implemented. I hope you get a chance to interact with them, but this is a demonstration of how we would like to work and how we want to move forward. Most of all, I want to thank all of those at different levels in government that we've really worked with closely during the assessment and during the conceptualization of this program. This partnership in this room and beyond is a testament to the belief that working together we can create positive and lasting change. Thank you.
And thank you. Our next speaker has been a judge in Spain since 1987. He is now the national member for Spain in the European Agency for Criminal International Legal Cooperation, Eurojust. He has worked in the Spanish General Council for the Judiciary and in the Spanish Constitutional Court. He was General Director for the Modernization of Justice in the Spanish Ministry of Justice and has served in different positions over the years, always in the criminal jurisdiction. Before joining Eurojust, he served as investigative central judge for criminal affairs. Please join me in welcoming one of our keynote speakers, Judge Jose de la Mata.
Thank you very much. Good afternoon to everyone. I have to tell you that I feel now a little bit more relaxed. Reason is that I arrived here 45 minutes in advance, but my computer decided to run out of battery just 3 minutes before the event started, and I had to go up to my room, back again, rushing everybody in order to find a switch to plug in the computer, but finally, here I am. That's the reason. So, special authorities, distinguished guests, ladies and gentlemen, dear colleagues, I want to say on behalf of Eurojust that I'm incredibly grateful to the organizers of this launching event for giving us in the agency the unique opportunity to present the work of our agency and share some ideas about legal cooperation between the European Union and the Caribbean. Organized crime, including trafficking human beings, in particular women and children, drugs and arms trafficking, illicit wildlife and timber trade, as well as corruption, financial crime, environmental and cybercrime, remain insidious threats to our people, societies, and economies. And mostly, these criminal activities do not know nor respect national borders and have always relevant transnational dimension. That's the first input. The second one is that the recent new agenda for relations between the European Union and Latin America and the Caribbean states that the European Union and the Latin America and the Caribbean countries are key allies that face common challenges around security and justice, and calls the agenda for a stronger strategic partnership between European Union and the Latin American Caribbean countries in several fields, including on the fight against transnational organized crime. Amongst others, by the way, the declaration calls for an increase of agreements and arrangements with Latin American countries on cooperation with Eurojust and Europol as a critical element to facilitate cooperation among both regions on transnational organized crime. On the other hand, the ultimate objective I have learned of the PACE Justice Project is to enhance the institutional capacities of prosecutors, courts, police, and prisons in the Caribbean to manage criminal cases effectively and efficiently. And I want to be clear. This will not be possible without rapid, effective, and respectful international legal cooperation systems in place, with particular attention to appropriated coordination mechanisms, creation and electronic transmission of requests for legal cooperation, and the use of effective tools, among them, by the way, for instance, joint investigation teams, having always present and having always taking always into account data protection regulation. The fact when it comes to international legal cooperation is that in most parts of the world, cooperation between judges and prosecutors from different countries is still based in lengthy letters of request, lengthy traditional procedures, and bureaucratic diplomatic channels. I want to share with you that in the European Union, the situation is slightly different, as over the past 20 years, we have jointly shaped a system in which national borders are no longer an obstacle to getting justice done. The system is built on two pillars: the principles of mutual recognition, trust, and direct communication among judicial authorities, and the support provided by Eurojust. So, replacing traditional mutual legal assistance with mutual recognition instruments has been a real game changer. Instead of complicated extradition procedures, we use European arrest warrants. Thanks to the freezing and confiscation order, it is now easier than ever to freeze or confiscate assets in another member state of the European Union. And the introduction of the European investigation order in 2017 gave us a simple and fast way of obtaining evidence located in any member state. An important part of Eurojust's work is precisely to support the judicial authorities of the member states with issuing and executing these mutual recognition instruments, providing assistance during every step of the criminal justice chain, from the very start of an investigation to the execution of sentences and compensation of victims. But we do much more than that. We offer prosecutors and judges a unique infrastructure to cooperate more effectively. We organize coordination meetings where countries come together to decide on the best prosecution strategy and resolve any obstacle in their way. Or we provide legal, practical, and financial support to joint investigation teams, more than 200 currently in place. We also capture our experience in strategic reports about a wide range of different topics, highlighting recurring challenges, best practices, and recommendations for the way forward. And these reports do not only provide practitioners with hands-on guidance for operational cases, but also support them as policymakers when they take decisions about legislation. But you know what? Eurojust may be an agency of the European Union, but our work certainly does not stop at the borders of Europe. Over the years, our cooperation with non-EU member states has proven to be a crucial factor in the fight against most forms of serious crime, including drug trafficking, organized crime, money laundering, trafficking in human beings. From the operational point of view, Eurojust provides assistance to all European countries in the transnational cases they may have with non-EU member states, and also the opposite. We provide assistance to these non-EU member states when they have transnational cases that may affect at least two European countries. In fact, in 2022, assistance was provided to almost 300 non-member states cases. An important part of this cooperation relies on a network of contact points. More than 65 jurisdictions all over the world, 15 of them in Latin American countries. And in addition to contact points, there is also the option of a more advanced cooperation based on an international agreement. This opens up the possibility to post a liaison prosecutor at Eurojust's headquarters and gives direct access to our operational tools. Currently, Eurojust is hosting not only delegations from the 27 member states, but also 12 liaison prosecutors from 12 other jurisdictions, the last of them from Republic of Moldova, having been seconded exactly the last week. So access to Eurojust means access to 40 jurisdictions all around the world. These international agreements are negotiated by the European Commission based on a 4-year strategy adopted by the European Ministers of Justice. The current 4-year strategy clearly reflects the need for enhanced operational cooperation between Latin America and the European Union. Argentina, Brazil, and Colombia are part of the 13 priority countries that were identified. Finally, this overview would not be complete without highlighting important strategic developments in the cooperation between Latin America and the Caribbean and the European Union, as it can provide a clear reference framework about potential next steps to take in the cooperation between the Caribbean and EU in the following years, hopefully with the support of the PACE Justice project. So, strategic working arrangements have been signed at the regional and bilateral level. In the regional level, a working arrangement with the Ibero-American Association of Public Prosecutors was signed in 2022. And Eurojust also has a memorandum of understanding with Iberred, that is a platform of, for electronic secure communication between central authorities. Iberred is an organization of the ministers of justice of the Ibero-American countries, and Ibera is this electronic platform. In the bilateral level, a working arrangement will be signed in a few weeks with the General Prosecutor of Panama. 15 countries in the region have already appointed contact points and keep regular and bilateral contacts with all the member states. Working together with them, by the way, a guide for Latin American Eurojust contact point was also developed. And then we have ahead of us a very interesting opportunity First, to discuss a possible regional working arrangement between the Caribbean and Eurojust, and then bilateral arrangements, should that be the case. At the bilateral level, finally, the possibility to obtain the appointment of contact points to open this regular bilateral strategic and operational collaboration between Eurojust and the different countries in the Caribbean. In addition, we have been closely involved in the activities of El Pacto, the European and Latin American Program of Assistance Against Transnational Organized Crime. They helped us a lot to strengthen this collaboration and these links of cooperation with different countries. And we expect to be closely involved as well in the second phase of the program that we hope will start very soon. Amongst other things, we host as well meetings and study visits there in The Hague. We facilitate contacts among national authorities, and we provide advice on the use of judicial cooperation on instruments. We hope that this same involvement will be achieved in the next future with PACE Justice project that may very effectively help both regions to improve the mutual knowledge of our legal cooperation system, that may help us to cooperate on strategic matters, to work together in the development and improvement of efficient mechanisms and tools that help to the expedient execution of the international legal cooperation instruments, and most important of all, to strengthen the support and assistance that we can together provide to our practitioners, judges and prosecutors in their fight against organized crime in our societies. Thank you very much.
Thank you, Judge de la Mata. Thank you. Now, our second keynote speaker has a vast knowledge of the Caribbean judicial system. She became the first female Chief Justice of the Eastern Caribbean Supreme Court in 2012. She first joined the court as a High Court judge in 2003 and was later elevated to the position of Justice of Appeal in 2009. She was awarded Dame Commander of the Order of the British Empire by Her Majesty Queen Elizabeth II in 2013. In 2018, she was called to the bench as an honorary bencher of the Honorable Society of the Middle Temple, became a Fellow of the Commonwealth Judicial Education Institute, and received an honorary doctorate of law by the University of the West Indies. In 2019, Dame Janice was elected an honorary Master of the Bench of the Honorable Society of Gray's Inn. Ladies and gentlemen, please welcome the Honorable Dame Madam Justice Janice Pereira.
Thank you. Yes, good afternoon, everyone. All protocols observed. Thank you. It is really a great pleasure and honor to be here. And I wish to thank the organizers for this opportunity to address you at this launch of the partnership of the Caribbean and the European Union on justice, the PACE Justice Regional Program. The PACE Justice Project, as you've heard, was conceived from the UNDP's own assessment of the justice systems of 9 nations across the Caribbean, which revealed that efficient access to justice is being severely undermined across the region by multiple systemic points of delay within several key stages of the criminal justice process. It is poised to combat various critical challenges faced by the Caribbean criminal justice sector and will provide much-needed developments within the relevant constituent institutions. Foundationally, we anticipate that this project will expand access to justice while strengthening the rule of law, human rights, and the equitable administration of justice in the Caribbean. The launch of this project is aptly timed as the CCJ Academy of Law's 7th Biennial Conference convenes tomorrow under the theme Criminal Justice Reform in the Caribbean, Achieving a Modern Criminal Justice System. Premised on the pursuit and maintenance of a just society, Caribbean constitutions recognize and guard the equal and inalienable rights with which all persons are endowed, including the right to protection of the law. Our courts, in their interpretation of the constitutions and their application of the rule of law, have been challenged by several outdated laws, modes of practice, and lack of optimization of technology, which have impacted citizens' access to justice in a tangible way. An accessible and efficient criminal justice system not only builds citizens' confidence and pride in their society, but remains a major indicator to stable government and economic growth, consistent with the United Nations goals and indicators for doing business in the Caribbean region. Thus far, the Caribbean, through partnership with the UNDP and other regional and international institutions, has made some strides in reforming and modernizing its criminal justice systems. However, the road to achieving a just society is ongoing, with a landscape that changes as society itself evolves. And so, with the visible advancement of justice systems across the world firmly in mind, we are confronted with the reality that the time is ripe for the Caribbean to pick up the pace, to deliver to its citizens a level of criminal justice administration which is commensurate to international standards. Justice sector improvement has long been a core priority of Caribbean governments, and notably, it is a key element of the CARICOM strategic plan. Despite our continued efforts as a region, several critical challenges remain as barriers to securing equal, efficient, and accessible justice systems for our citizens. As your survey will no doubt have revealed, Caribbean justice systems are plagued by an overwhelming backlog of cases, particularly in the criminal justice system. This has been occasioned by a keenly felt lack of human and technological resources, which has stymied the work of investigators, public prosecutors, and the courts. The unfortunate domino effect which ensues is that we now face concerningly high levels of prisoners on remand for extended periods, for as long as 6 years in some instances. And so the story, which was extraordinary, but not so extraordinary, really rings true. We struggle with gaps in the proper implementation and execution of restorative initiatives, such as support for survivors of violent crimes and for offenders re-entering society. Our efficiency is further stunted by a tremendous lack of facilities oriented to deliver a gender-responsive approach to justice that complements our efforts to fight discrimination against vulnerable groups at all levels of the administration of justice. A gendered approach ensures that the gatekeepers of justice, including the police, the courts, and the correctional facilities, are sensitized to the ways in which the differential experiences of men and women, both as victims and perpetrators of crimes, expose biases which bar them from the protection and enforcement of their rights under the law. The PACE Justice Project offers our region strategic and effective solutions to the outdated and laggard procedures and resources which perpetuate injustice, insecurity, and inequality within our justice systems. To achieve its ultimate objective of enhancing institutional capacities for the efficient and effective management of criminal cases, the UNDP and its partners are undertaking the development of interventions characterized by three main connected goals. One, enhancing technology and systems training to improve the efficiency of criminal justice administration. Two, empowering stakeholders through building capacity across all elements of the administration of justice with a focus on service design and delivery. And three, strengthening national and regional processes and procedures for improved efficiency and accountability within the justice sector. These interventions will target several impediments which have strained the efficiency of our justice systems. In particular, the weakness in police data capture, outdated court case handling systems and processes, paper-based evidence management systems, limited digitalization of correction systems, processes, and witness tampering protection, just to name a few. The procurement and deployment of enhanced technology and infrastructure systems will no doubt assist with streamlining the various processes which form part of criminal case management and reduce the inaccuracies and delays often caused by paper-based methods. The PACE Justice Project, as I was reminded, intends to develop locally owned, purpose-built software for police, courts, and prisons, which will be designed, tested, and scaled across the region with interoperability as a primary functionality. This cross-sectional approach will automate information sharing between the different institutions of the justice sector, providing the police, directors of public prosecutions, lawyers, and the courts with efficient access to updates on case information, evidence, filings, and events. A federated case management system with automated data exchange is sure to facilitate ease of cross-institutional processes, saving time and allowing for the reallocation of human resources to other important tasks for greater efficiency. So far, I am proud to say that the Eastern Caribbean, which represents in the OACS 9 member states and territories, 3 which are British Overseas Territories, is well underway in its own information and communications technology transformation, having adopted the use of an electronic portal for digital case management of its civil and commercial court matters, as well as its civil and criminal court of appeal matters throughout the Eastern Caribbean. We have also launched in the lower judiciary and the magistracy, and we hope to launch and involve all the criminal cases very shortly. The court has also recently launched the new Civil Procedure Rules of 2023, which now bears corresponding rules of procedure to govern the use of the portal. Further technological improvements at the court include use of virtual platforms for the conduct of remote hearings from any suitable location. Significantly, this step have caused a reduction in delays caused by a former reliance on a paper-based system, a marked increase in the clearance rates of cases before the court, a more efficient utilization of our human resources, and greater ease in accessing and managing case files. What is clear is that I think courts have begun the work, but clearly more needs to be done. The PACE Justice Project now provides our region with a more holistic framework for modernizing our justice systems and an opportunity to enhance our efforts by expanding our technological resource capabilities, strengthening our capacity to gather, maintain, and analyze data, and improving our performance standards. I am also advised that the PACE Justice Project will target the empowerment of stakeholders within the justice system through training and capacity building. The initiatives which fall under this umbrella will be crucial to achieving the much-needed collaborative dynamic which is presently missing amongst the institutions within the justice sector. The training of all stakeholders in the justice system, including the police, staff at the offices of the Director of Public Prosecutions, court staff, judges, defense counsel, and prison staff, will ensure a more seamless integration of federated digital case management systems and will build long-term technological capacity in each institution. The project will also develop and implement gender-sensitive training and capacity building exercises among judges, prosecutors, case managers, registrars, and clerks of court, police officers, crime laboratory staff in critical stages of the criminal justice process. Such efforts will serve to enhance access to justice, particularly to underserved and vulnerable groups, including but not limited to women. Efforts to empower stakeholders in the justice system will also feature specialized support for victims, witnesses, and the rehabilitation of offenders. These initiatives will deliver expanded witness protection arrangements, including a regional witness protection program, survivor support units or councils and call centers, dedicated mental health resources, aftercare programs, entrepreneurship and vocational training, transitional housing, and other social protection systems, which will galvanize community-level support to prepare prisoners for release. These strategies align suitably with our goal to vastly improve the experience of justice administration for victims as well as offenders, and to sharply reduce the incarceration rates in the Caribbean, particularly as impacted by the number of reoffenders in our prisons. The third component of the PACE Justice Project targets the improvement of coordination, processes, and procedures within our justice systems. Several legislative changes will be necessary to realize practical justice reform, such as amendments to update rules of evidence and rules of procedure to support the implementation of remote hearings, bench trials, criminal mediation, diversion programs targeting youth offenders, electronic evidence submission and storage, along with other innovations. Coordination efforts will include, among other initiatives, filling the gaps in existing laws, rules, or procedures by developing or adopting model criminal laws. I have been on that topic, I think, for a number of years, model criminal laws, conducting studies on reform initiatives, developing a roster of regional experts as a more readily available resource to assist judges in assessments, exploring new and strengthening existing legal aid models through strategic partnerships with bar associations, defense lawyers, and government. National and regional coordination building will also be achieved through a series of meetings, seminars, and workshops, which will facilitate cross-agency dialogue in respect of law enforcement, custodial care, and rehabilitation of inmates. The improvement of our processes and procedures, along with coordination building, will allow us to truly achieve the benefits of having modernized our justice systems, fulfilling our agenda of making justice administration more accessible and efficient throughout the region. I would be remiss if I were not to come to a close without extending my profound gratitude to all those persons who have been instrumental in actualizing the PACE Justice Project. Historically, the UNDP has left an indelible mark on the improvement of justice systems across the Caribbean through various partnerships, such as Jurist, which in partnership with the CCJ has served to improve women's access to justice in the Caribbean, by establishing global best practices that are gender responsive. I have no doubt that the PACE Justice Project will achieve equal or even greater success in its objectives. And so I encourage all stakeholders of the justice system to lend their full support to the execution of this project as we continue our journey on the road to achieving excellence in the administration of justice in the Caribbean. Thank you.
Thank you, Dame Madam Justice Janice. To close this segment of the proceedings now, we have the current Attorney General and Minister of Legal Affairs of Barbados, a position he's held since May of 2018. He previously served in the Cabinet from 2003 to 2006 as Minister of Industry and International Business and Attorney General and Minister of Home Affairs. An attorney of 34 years' experience, he was appointed Queen's Counsel in 2006 and was a senior partner in George Walton Payne and Company from 2008 to 2018. To deliver the closing remarks, the Attorney General of Barbados, ladies and gentlemen, the Honorable Dale Marshall.
For those of you who are church-minded, you would know what the Nunc Dimittis is. So this is the Nunc Dimittis speech. The one given just before you exit the church. But I am grateful, though, to have an opportunity just to share a few words, especially coming after you, Judge, and you, Madam Chief Justice. Hearing you has been inspiring, and especially given that you are speaking from the OECS experience, I believe that there is a lot that Barbados can learn from you. The 8 countries are very different in culture, very different in experience, but we do have a common problem with backlog in our courts, and there's a burning need for criminal justice reform. Before I launch into my written text, let me give you the Barbadian context. When we came to government in 2018, I asked the DPP to provide me with figures on the backlog in our Supreme Court. I believe at that time the figure was just about 900 cases to be done in what used to be called the assizes. So 900 cases to be done in the Supreme Court. But our problem was that we only had 2 criminal judges. Now, mathematics is not my strong point, but 900 cases by 2 criminal judges would tell you what each judge's workload potentially could be. Added to that, Madam Chief Justice, is the fact that at that time, our judges rotated in and on and off of the criminal bench. So you would serve a stint on the criminal bench, develop an expertise, hopefully, but by the time you got things rolling, you were off to the civil bench. And occasionally you would find the judge coming up to the criminal bench for whom criminal cases may or may not have been their forte. That equation simply could not be balanced. So we immediately set about increasing the number of criminal judges to 5. And we thought that 5 would have made a sufficient dent. It did not. And therefore, only a year and a half ago, we agreed to increase the number of judges to 8. But of course, again, the equation has to balance. And the DPP said, well, I'm happy for 8 judges, but you have to give me more prosecutors. And we had to find more courtrooms and more court marshals. And somehow or another, the Prime Minister has still seen it fit to keep me in her cabinet and to keep me on her good side. But I remind her every day that she committed to the people of Barbados that the first call on our national resources would be citizen safety and security. So that has been my get out of jail card. I hate to use that term in this audience. That has been my good luck card, so to speak. But even with those initiatives, it is evident that we still have a long way to go, because if we fixed, and we haven't fixed it, but if we've tried to fix the judicial side without dealing with the capacity building in the other areas, the technology, because we are still paper-based, aren't we, DPP? Very much so. And files still go missing. We don't know where they've gone missing to, but that's the nature of missing. And then, of course, we have the police part of the equation that also has to be fixed, because our police, and you know, one of our challenges is, I may take longer than 10 minutes. One of our challenges is that one of my parliamentary colleagues called me at 6 o'clock in the morning, and she said, AG, there's a lady in my constituency, she's been screaming at the top of her voice from 3 o'clock. And, you know, she's obviously a lady with a mental problem. Do you think we should call the police? I said, but no, you can't call the police. That's not a law enforcement issue. The point is, and anybody, I guess it's a Caribbean thing, the slightest thing that goes off kilter, the first thing to do is to call the police. And if they don't show up, then of course you get a problem. But that inevitably takes the police away, Leslie, from their policing duties, from their investigating duties. We've even taken a decision that very shortly our police officers will no longer be responding to traffic accidents. Unfortunately, before that decision came into play, I had a traffic accident in April. Well, it wasn't that fault, it was somebody rear-ended me. And it was the most embarrassed person anywhere to be found in Barbados, because here was AG saying, police need to stop coming to traffic accidents. 4 police turned up. Well, I guess, if I said that they turned up in record time, you would say, well, and they turned up in record time. But let's talk about technology. We gave our police officers notebooks, tablets, about 3 years ago, and we said, this practice that you have of coming to the scene of an accident and taking out a book, and often the rain is falling at the time of the accident, so the umbrella is clutched under one arm, and not much later, and you're trying to write the notes, and we said, no, stop that. You have these tablets. Well, 3 of the 4 police who turned up came with really big blue notebooks and proceeded to say, and what is your name, sir? Well, so the point I'm making, though, and if I appear to be a little bit humorous, forgive me, but all sides of the equation has to balance. And if we fix the court and don't fix the police, and if we don't fix the DPP and don't fix all, you know, we simply will still have the problem. And Madam Chief Justice, your counterpart in Barbados lamented only earlier this week, and it really has become a common refrain, that we have far too many lawyers practicing criminal law. So, and of course everybody wants the best, and there are only about 4 or 5. If you have the other problem, please send me some. But there are only a few people who, I guess, in every profession, but the DPP, I think, would agree that you want to start a case, and the famous defense attorney, who you have the right to have, is already in a case in another court. And so, now tell me if you don't have this problem in Belize. But different cultures, different backgrounds, but I have a feeling that those are the common threads that we all face, and that's why the Pace Justice Project is so important. So, protocols having been observed. No, I promise you, I'm not going to start from the top. But let me begin by expressing my gratitude to the EU for funding this important and timely project. Its aims are laudable, and there's a lot that we have riding on it. I hope that this project will truly be a foundation upon which all of us in the region can build, and a foundation that will see our commitment to the orderly development of our societies and to the safety and security of our citizens realized. Everybody in this room is keenly aware of the ethics of an inefficient criminal justice sector. You're aware of the implications of an inefficient criminal justice sector on human rights, the perception that the system may be skewed in favor of the criminals, the impact on victims and witnesses, all leading to a lack of confidence in the ability of the state to govern and manage. And I say this not looking at all to apportion any blame, because that gets us nowhere, but simply to highlight this vexing issue that has become a top priority for this region as we watch the explosion of crime, especially firearm crime, across the region explode. And of course, the effects of firearm crimes are disproportionate to our relatively small sizes. The need to modernize the criminal justice sector, particularly in relation to the reduction of backlog, has now become one of the urgent priorities for policymakers at the highest levels in our respective countries. Earlier this year in Trinidad, CARICOM heads of government convened their own high-level symposium on crime. And we discussed then, I say we, I was just in the audience, I'm not a head, but the gathering discussed the urgent need for reform of the systems. And I noticed recently that the Trinidad and Tobago Chief Justice expressed his concern about the level of crime and the proposed reforms that he would like to see brought into play for the administration of justice there. Here in Barbados, one of our High Court judges, Justice Graves, has also recently spoken on the matter, pointing out that the clearing up of the backlog of cases, criminal cases in our courts, can lead to a reduction of crime as well. And that judge pointed to the link between quick trials and reduced crime. I was not generally a bad behaved child, but there was a big difference when my mother said, I'm going to beat you now. Or when she said, wait till your father come home. Wait till your father come home was the best words I could ever want to hear, because I had another 4 hours to continue to behave bad. On the other hand, when that punishment was coming immediately, I had to behave immediately. And in many ways, charging an individual in 2007 for a murder, and in 2020, 21, 22, 23, that case has not come off, well then I think you would appreciate why I've given that analogy. Added to these ideas are the strident calls for stiffer conditions related to bail, and also no bail for serious offenses. Prime Ministers Gonzalez and Rowley have both opined on that particular matter. In April and May of this year, my ministry held a 2-day symposium on criminal justice reform. All of the players were in the room, but it was a very difficult decision to have at some points. You had the defense judges taking opposite positions to the police. There's a natural tension between them. You had them taking opposite positions to the DPP, because there's a competitive tension between them. And then, of course, the judges fell under the scope for granting adjournments too easily. Some said that they gave bail too easily. Others said that they didn't give bail easily enough. It was a very, very difficult discussion to have at some points in time. It should have been a 1-day conference. It ended up being a 2-day conference. But I'm pleased to say that arising out of those difficult decisions, we've managed to establish a criminal justice reform committee chaired by our Chief Justice, and work has started on an ambitious program which we hope will be supported by this PACE project. The stakeholders in our criminal justice sector are all represented on the committee. I therefore wish to commend the PACE Justice Project for the breadth of its coverage, working with each stakeholder in the sector to provide either technological capacity, human resource development, legislative drafting, procedural matters, and the use of data, better data, on which sound policy can be made. Relationship building and the sharing of best practices are also key components of the project. And in the region, we're happy that there are some good examples. We can learn from Jamaica with the clearance of their backlog in that country's parish courts and from the successes in our sister islands in the OECS. An inefficient criminal justice system can rapidly become an ineffective criminal justice system. It costs our people, it costs our businesses, and it costs our taxpayers. And in that vein, I have to mention that these costs run deeper than the cost of keeping the system up and running. As I said, we've now increased the size of our judiciary and a whole set of other things. But we now have to add to that the fact that the judiciary has not been hesitant in awarding damages to accused persons whose trials have been delayed for so long that those persons' rights to a fair trial are found to have been breached. Thus, despite Barbados increasing the number of criminal court judges fourfold, despite the increasing of the size of the establishment in the office of the DPP and other departments in order to increase the rates of prosecution, the state now has to add to those already heavy fiscal burdens the burden of meting out a different kind of justice to the accused. How ironic is that? But that is a discussion for another day, and good judgment and the affluction of time dictate that I bring my presence at this podium to an end. Ladies and gentlemen, I hope that you will join me in both thanking the EU and UNDP and congratulating the EU and UNDP for funding and designing the PACE project, and wish them and us every success as we move together towards implementation.
Thank you, AG. And now we're going to take a little break, and this is where we will stop the stream, allow you a little time to stretch your legs, and we'd like to invite you over to the stairs to take a photograph. There's an official photograph of this afternoon. So we would like you all, the team at the UNDP will lead you out. We go for the official photograph, and then you will return, and we will go on to the second half of the proceedings where they will get into the details of the project.